Okay, so I've said this before that sometimes, it's important to be mindful of who you think you're going to rip off and or try to make an example of because you might actually be talking to somebody who is your superior in the future, right? For instance, who remembers what happened with Eisenhower during the pensioner strike when he was serving under who he was serving under. Who was he serving under at the time? See, this is the thing, right? At the time, Eisenhower was just a subordinate officer, and Douglas MacArthur was in charge. And he had to serve under MacArthur. Then during the war, he served under MacArthur. And then, well, what happened? He became president, right? And so those things that MacArthur did and put on him, it made a difference later on when he was trying to get the president to pay attention to him. And then there's what do you do about that journalist, right? That guy, he's got some things he's doing and he's writing these articles in the paper saying some really provocative stuff, talking a bunch of smack about trust and calling them bullies, telling all the secrets, putting all the numbers out there. I mean, does it make a difference to you that that's one day going to be a justice of the Supreme Court? Are these things really happen in American history? Did you know that? Here's something that actually happened in Texas history. I read about this guy once. There's this old book, and I read through this book, and he had this opinion, an excerpt of an opinion of his. It's a very important old book in Texas. It's about 100 years old. It's coming up on its 100th anniversary, this book, about some of the justices and some of the attorneys general, the early times. It's kind of how you find out about whatever happened during the Civil War. You know, there were three three attorneys generals during the Civil War that ended up quitting, and two of them, there's no record of anything they did as attorney general, right? Who are those guys in the future? Hmm? Well, I don't know who they are in the future, but this other guy that was in there, this justice, his name is John Ireland. He wrote this opinion, and the excerpts from this opinion, they have a very, very compelling invocation where he's talking about equality. And despite other things he did politically, this particular opinion has a very, very strong foundational argument about what he was talking about. But did you know what he did before he became a justice of the Supreme Court? Well, apparently, he was in a situation where he was being chastised and tormented by this other guy who happened to be a judge, right? And I'm looking at this. Is this true? It's not done ex post facto as some sort of scheme to defraud, including by luring people in that actually have a claim pending before the court as a way to try to create some sort of alternative reality for bucket shopping? Maybe not. It's 14th Legislature, Senate Journal. And I just want to read here. Charge 5. Fifth charge. Because when the Supreme Court, upon Manny's refusing to obey their summons, issued their capias for him, he abandoned his court, which was then in session in Guadalupe County, and skulked like a criminal for 5 days. And when found in a different county and arrested by the sheriff of Travis County, said Manny deceitfully promised said sheriff that if he would release him till morning, he would meet him and go with him before the Supreme Court, to which he pledged his Masonic word. Now, as I'm saying this out loud, it may have been Maney, right? Was that his name? District Judge Maney of the 22nd District. Apparently, he was removed from office by the Senate. There were a number of judges, apparently, during this time frame that were removed by the Senate, including in consideration of a committee that Amzie Bradshaw served on. But the thing that's important about this transcript is two things. First of all, this is the first, and then second transcript. There's actually a correction that apparently was a misrepresentation or a misprint of the date of the proceeding. It was off by a year. So they had to add a special record to correct the date. But that record on the date correction did not happen until sometime later after the initial proceeding it describes. At least it's reflected online right now, right? But what this discusses is the implication of a sitting judge that's presumably, or at least actually legally, bound to the Constitution, attempting to engage in violations of the Constitution that also involve a pledge of his word as a Mason. And that presumably somebody else elected to office, as a sheriff is, and that is constitutionally beholden as a sheriff would be, is agreeing to engage in some sort of ulterior or alternative legal process that's not constitutionally grounded based upon the Masonic word. And this is actually listed as a formal charge. Now, the implications of the constitutionality of allowing for the word as a Mason to be a form of promise that allows for a violation of the Constitution or gives some sort of, shall we say, undue influence in terms of performance of official duties based upon the pledge of one that is a Mason is included in consideration of the other charges that are of relevance in this removal case wherein the judge was actually removed. But let me just remind you, this is also the second time I've encountered this specific implication that some sort of bond as or between Masons or some sort of engagement with Masonic practice outside of an understanding that I already have that it's constitutionally, it's bound by the Constitution, and also the Constitution of the state of Texas and the early Republic of Texas precluded the privileging of any sect, which would also include Masonic sects. But there's also the information from a former Inspector General of the Scottish Rite that was at a public presentation of the Eastern Star, the Order of the Eastern Star, saying that the performance of Masonic ritual never precludes the implementation of the Constitution and is never superior to the Constitution. That you cannot use Masonry or a Masonic commitment as an alternative to adhering to the Constitution. Now, does it make a difference that the Inspector General of the Scottish Rite said this at a convention of women that were members of the Order of the Eastern Star? I contend it was absolutely appropriate for him to do that there, and he let people know within his own authority that that was inappropriate, and he meant for the women to know too. And so now we're at the situation where the documents that are available through the state of Texas government have attested to the fact that there was a court, there was a legislative session specifically about impeaching a judge. And among the charges that were considered as impeachable offenses were allowing for some process alternative to adhering to the Constitution to take precedence. It is important. Why? Because the people he is excoriating and subjecting to this kind of torment happen to be a future Justice of the Supreme Court. If nothing else, at the time, they're discussing it in the consideration of them as members of the legislature. But they were also, at some point, what would have been his superior, even within the realm under which he was exercising his own authority as a member of the government. This is one of those things that, is very important when you take into consideration the consideration of superior versus subordinate. And just so you know, it's apparently a part of the history every bit as much that there are things such as these sorts of efforts to try to subvert the Constitution and engage in some sort of privileging of sect, including in some sort of ritual performance that subjects people to violations of the law. They're impeachable offenses.